I'm Marco Brown, divorce attorney here in Salt Lake City, Utah, coming to you answering the most commonly asked questions on the internet about divorce. This question is, when does a court order become effective? Now, most of the time when people ask this, what they're asking is, hey, I have a divorce decree. When did the divorce decree become effective? And that's a written order of the court. That almost always becomes effective upon signing by the judge. There's usually a date and time that it was signed by the judge, and it was effective as of that date and time. Okay, and that's how it works in Utah. I think that's how it works in the United States, in all the states. But maybe it's a little bit different depending on the state. That's certainly how it works in Utah. The other thing you need to consider is sometimes you go to a hearing with a judge. So you have a motion and you have a hearing, and the judge will give an order, but the order is an oral order. The judge just says something, okay? Now that oral order is going to be transcribed, it's going to be written down, and it's going to become a written order. The question is it an order from the court when it's spoken or when it's written down? The answer to that, and here in Utah, and I'm pretty sure it's the same anywhere in the United States, is when the judge says it. Okay, so it becomes an order of the court from the moment the judge says it from the bench. And then the written order is simply a transcription of the order that has already been effective when it was spoken by the judge on the bench. So hopefully that is clear to everybody, but you got those two situations. And just keep in mind that if you go to a hearing and the judge says something, right then at that moment, that is the order of the court. You're not waiting around. There's no playtime between when the judge says something in court and then when it becomes an order of the court. You have to assume that it's an order of the court when the judge says it, when you're there in court.